At first glance, this hearing feels like any other routine court proceeding. But the charges about to be read carry serious, life-altering consequences. The defendant is facing multiple felony counts, and what unfolds in the next few minutes could shape the rest of his life. The decision made here could mean decades behind bars, or the possibility of accepting a deal that significantly reduces that time.
Okay. All right, so are you Kendrick O'Veal?
Yes, ma'am.
You are charged with evading arrest or detention with previous conviction, and that's from August 31st of 2025. That shows that you were previously convicted of evading arrest or detention July 22nd of 2011. So that's what makes it a state jail felony. Then the indictment further alleges you were convicted of attempted robbery, a third-degree felony, March 28th of 2013. And after that was final, you were convicted of assault, a third-degree felony.
This is where the legal stakes start to rise. Those prior convictions aren't just minor background details. In a legal system, they can dramatically increase the punishment someone faces. This is known as sentence enhancement, where repeat offenders are treated more harshly. What might have been a relatively smaller sentence can suddenly become far more severe simply because of a person's criminal history.
September 11th of 2019. And so what that means in that case is that if you go to trial and you're found guilty, and those prior convictions are true, the range of punishment would be enhanced to a second-degree felony, which is between 2 years and up to 20 years. Do you understand?
Yeah.
And then, in cause number 25 DCCR 1777, you're charged with unlawful possession of a firearm by felon. And that is
one of the charges here is especially serious. In many states, once someone has been convicted of felony, they are legally prohibited from possessing a firearm. So if this case goes to trial, the jury will focus on one crucial question. Did the defendant knowingly possess that firearm? That single point could determine whether the charge holds up in court.
From August 31st of 2025. That indictment alleges one prior felony conviction, the one from 2019, but the state can file, and I anticipate they would file, a notice of enhancement because that 2013 was left off of that indictment. And so what that means in that case is if you're found guilty and if those prior convictions are true, you would be considered a habitual offender with a minimum punishment of 25 years in prison, up to 99 years or the rest of your life. Do you understand? And then
did you notice that detail? The label of habitual offender changes everything. With that designation, the minimum sentence jumps to 25 years and could even reach life in prison. At this stage, the courtroom isn't just discussing accusations anymore. They're discussing the real possibility that someone could spend the rest of their life behind bars.
Finally, in cause number 25 DCCR 1778.
Once we get all these done.
You're charged with a third-degree felony offense of deadly conduct discharging a firearm from that same date of August 31st of 2025. It does allege those two prior felony convictions. Again, what that means, if you're found guilty and if those prior convictions are true, you would be considered a habitual offender in that case also, with a minimum punishment of 25 years, up to 99 years or life in prison. Do you understand?
Yes, ma'am.
In all of those cases I have here on this tablet,
And now we arrive at a pivotal moment in many criminal cases, the plea deal. Prosecutors often offer a reduced sentence to avoid the time and cost of a full trial. But accepting that deal comes with a major trade-off. It usually requires the defendant to admit guilt. Rejecting it, on the other hand, means taking the risk of going to trial and leaving the outcome entirely in the hands of a jury.
A plea bargain rejection in each case that you've signed with Mr. Parker that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty in your cases, to go on, probably it looks like counts 1 and 2 for a 15-year term instead of that habitual. And so in 2 of the cases, a 15-year term, And then
It's 15 on all, concurrent on all of them, Judge. Yeah, because it's state jail is it.
oh, I opened the wrong one. Sorry. Hold on. Y'all don't want me to do that. That's a 30.
Oh, that's my next one.
Sorry. Okay. So 15 years in all three cases that would run concurrently, which means together at the same time. Do you understand what the state has offered you?
Yeah.
And so you have every right to reject that offer and have all three of your cases set for trial. I just want to make sure you understand what the possible consequences are if you go to trial, what your options are if you wanted to enter a plea of guilty in your cases. And do you understand all of that?
Yeah.
And do you want to reject those offers and have your cases set for trial? All right, we'll get that done. I do want to, is there any reason to believe that these offers would change?
Not at all, Judge.
So, Mr. Oville, I want to make sure you understand that after today, unless there is new evidence that is discovered by either your attorney or the state's attorney, I will not accept these plea agreements again. Once it's on the trial docket, it either goes to trial, you can plea open to the court, or to some different amount or negotiated punishment. Do you understand? Okay, so I will get your cases set for trial. Mr. Oakville, Mr. Parker has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me here as a court-appointed attorney. With your permission, I can release him and I can appoint a new attorney today who could begin preparation for trial a little quicker. Is that okay with you? Okay, so Mr. Parker, you're released. Mr. Oakville, we will appoint someone today. They should be out to see you very soon to begin preparation for trial.
I get it.